there is no indication whether samples have been taken by the state. And once again, the defense has no access to the police docket at this stage, Your Worship.
Once again, from that unit, they sniffed out absence.
Correct, Your Worship. Your Worship, the investigating officer, Your Worship, the other factor which the court should consider is what was told to the accused upon her arrest, that the time of death was between the hours of 4 a.m. and 5 a.m. on the 14th of May 2025. This was at the time when she was placed under arrest, Your Worship, and detained at Roodepoort SAPS. Jayden-Lee went to great lengths in testifying that he has a sworn affidavit from the night shift guard, which is also confirmed in the occurrence book. The night shift guard made entries to the effect that the applicant arrived at 4 a.m. and left at 5:30 p.m. This has been rebutted by the applicant, who produced evidence to this court that she only arrived at Swazi Place at 5:22 a.m. that morning. There is also evidence to the fact that from 5:30 up until at 6:25 that morning, Jayden's body was never recovered or seen by anyone. Various tenants were going to and from work using the very same staircase where Jayden's body. So at this stage, the assumption has to be drawn that after the applicant had left Swazi Place, somebody placed Jayden's body on that staircase. Your Worship, all of these submissions goes to show that the strength of the state's case is not as strong as initially perceived. And it is our humble submission that is one of the factors that the court should consider when considering bail is, does the court have a strong enough case to secure a conviction against the applicant at the trial? Now, by Sergeant Diko's own testimony, he had informed the court that there is various outstanding investigations. There's a minimum of 5 state witnesses' statements that could have been obtained in the past 2 months, but he had failed to do so. This Honorable Court is not tasked with determining the innocence of the guilt. Not tasked with determining the innocence or the guilt of the accused at this stage, but rather determining whether she is a flight risk and will stand trial. Your Worship, won't burden the record, but I'm just going to make reference to more recent case laws, Your Worship, that will assist the court in reaching a suitable decision. The first being the matter of State versus Kula, K-U-L-A. It's CAB 02/2023, which is a Northwest Division decision. Your Worship, for the next 3 matters that I refer to, I have taken the liberty of making copies for Your Worship for ease of reference. Your Worship, I'll refer the court to paragraphs 9 to 15, where the court stated that in seeking to establish the presence of such factors, the court is to act as proactively and inquisitorially as may be necessary. That when an accused person applies for bail, the court should consider that appropriate conditions are imposed to minimize possible risks. Where the public peace is a factor, requisite exceptional circumstances are indeed present. Not just the likelihood, Your Worship, that the accused may do be exceptional circumstances that are present to convince the court that it is not in the interest of justice that the applicant be released on bail. Your Worship, paragraph 15 goes on to state that bail serves not only the liberty interest of the accused, but the public interest by reducing the high number of awaiting trial prisoners clogging our already overcrowded correctional system, and by reducing the number of families deprived of a breadwinner. Your Worship, I then refer Your Worship to S versus Kweleta. It's spelled Kweleta, CANR 115/2024. It is an Eastern Cape division. It was reported on the 27th of February 2025. The relevant factors, the relevant paragraphs which I refer the court to are paragraphs 33 and 34, as well as paragraph 44. Just to read paragraph 33 and 34, Your Worship. Further, the basic purpose of bail from society's point of view has always been and still is to ensure the accused's reappearance for trial. But pre-trial releases serve other purposes as well. The purposes recognized over the last decades and often dispositive for the fairness of the entire criminal proceedings. Pre-trial release allows a man accused of crime to keep the fabric of his family intact, to maintain employment and family ties in the event he is acquitted or given a suspended sentence or probation. Further, it spares his family the hardship and indignity of welfare and enforced separation. It permits the accused to make an effective part in planning his defense with his legal representative, locating witnesses, improving his capability of staying free in the community without getting into trouble. Your Worship, it is evident that in this particular case, taking into consideration the little evidence that has been led, there is a strong possibility that the accused could be incarcerated for more than a year, awaiting a date on the High Court roll or the Regional Court roll. And there is a possibility that new evidence can present itself, new suspects can be arrested, which can also take the investigations into a different direction. Another division of the SAPS, be it the Hawks or a serious and violent crime division, take over the investigation of this matter, as she verily believes that somebody has gone to great lengths to defeat the ends of justice and to implicate her in this matter. The applicant also appeals to the offices of the DPP for proper investigation and an opinion to be made prior to the furtherance of prosecution in this matter. Your Worship, I'll refer the court to one last case before I conclude, and that is the matter of S versus Saul, spelled S-A-U-L-E, CA and R93/2023. It is an Eastern Cape Division judgment whereby there was public outcry in the matter. The appellant, was charged with murder, conspiracy to commit murder, malicious injury to property, and possession of unlicensed firearms and ammunition. It was alleged that the appellant had hired 3 hitmen to kill the complainant in the matter. Your Worship, this matter, which a copy will be made available to Your Worship, dealt with the issue of public outcry and how public outcry influenced the court of quo to deny the appellant bail. And over a period of time, the court realized that the public outcry no longer existed. It is the same with this matter, Your Worship. On the first appearance of the accused, there may have been 200 to 300 people. And as the matter progressed, there are fewer and fewer people protesting outside this court. This does not mean that the public are not hurting or disappointed by Jayden's death. It simply means that people are often influenced by public opinion. They are influenced by social media influences. But after many community or members of the community had an opportunity in this particular matter to watch it televised live, they may have changed their opinions as to the innocence or guilt of the appellant, or the applicant, sorry, Your Worship. As is the case of the article that was referred to and ended up as an exhibit, the matter of State versus Mduduzi, the court will see that in the article, Your Worship, on the front of the article, there are pictures of protesters that are standing outside with placards opposing bail for the applicant in that matter. Your Worship, that was a premeditated Schedule 6 murder bail application where the public outcry played a major part in the opposition of bail. DNA results that are still being awaited, and he has no knowledge as to how long it will take before that evidence becomes available. So it is safe to state that the investigations are far from complete at this stage, and the matter is not yet trial ready. Your Worship, it could take 3 to 6 months, especially in a murder matter with such complicated evidence outstanding, before this matter is trial ready. Now, the accused has to be denied her liberty whilst waiting for the state to get its house in order. Your Worship, it is further submitted that the accused is unaware of the identity of the state witnesses, save for those that have been revealed by the state during the course of the bail application. There is no evidence before this court at this stage that the accused has interfered with any of the state witnesses, or that she has attempted to interfere with any of the state witnesses, even after arrest. Your Worship, the court, if that is one of the concerns of the state, the court may simply impose bail conditions that the accused is not to directly or indirectly interfere with any of the state witnesses. Your Worship, the accused has a fixed address. She was arrested at her mother's place of residence, which has been verified by the investigating officer as the residence where she has been residing for the past 2 months since the passing of Jayden. Your Worship, the accused, on her own free will, did provide an alternate address and is willing to relocate to any address that the court deems appropriate until the finalization of this matter. In saying that, Your Worship, the accused, at the insistence of the investigating officer, had provided an address in KZN, which is a biological father's home address, which has been verified by the police and is deemed to be suitable. It is my humble submission, Your Worship, that at this stage, bail can be granted for the accused, and if the state feels that they require alternative redress, that can be supplied and verified without becoming public knowledge. And the applicant can relocate to that address within the province of Gauteng, Your Worship, until the finalization of that matter, if there are concerns that she may be interfered with. The applicant is also willing to abide by any bail conditions that this Honourable Court may deem appropriate, be it signing conditions or reporting conditions. Your Worship, at this stage I'll refer the court to S versus Bennett, which is a 1976 volume 3 decision, where the court, in considering the bail application, should determine whether any objection to the release of bail cannot suitably be met by appropriate conditions pertaining to release on bail. At this stage, Your Worship, there are no complaints whatsoever under oath confirming that there has been any interference of the potential witnesses that the state intends using at the trial. There is absolutely no evidence that the accused will not attend her trial if she is released on bail. In addressing the court as to whether the accused is a flight risk, Your Worship, the annexures to the applicant's bail affidavit confirms that as far back as 30th May, the applicant was aware that she was a suspect in this matter, and that the Bishop Veron, who was counseling her, had confirmed same with Major General Kekana. There was a meeting held with the investigating officer, Sergeant Diko, and Lieutenant Colonel Sia Keng, where it was made abundantly clear that if the accused is a suspect in the matter and is wanted for questioning, or for a warning statement to be supplied to the state, that my officers will voluntarily bring her to the police station and cooperate with the police. This indicates that the accused had absolutely no intention of fleeing or evading arrest. The applicant had in excess of 6 weeks prior to arrest, Your Worship, to apply for a passport, to flee to a non-extradition country. The applicant does not even possess a passport, Your Worship, and should not be considered a flight risk. The applicant does not even have the means to relocate outside of South Africa. The court should also consider that the applicant is a first offender. She has no previous convictions and no other pending matters. And this makes her a suitable candidate for bail.
And so she went on an elaborate scheme, so to speak, to conceal her actions by reporting him as missing, knowing full well that he laid harm in her unit. Furthermore, She then pointed to the transport driver as the last person to have been with Jayden, and thereby causing him to be a suspect and causing his home or house to be searched. Yes. And thereby subjecting him to that infinity. And lastly, Your Worship, it is our contention that for whatever reason, the applicant returned then on the 14th, on the morning of the 14th of May, at around 4 a.m. And I want to use the word trade, but she took out Jayden from the unit number 13, and then placed him in the passage just a few meters away from the unit. Now, that is the totality of the evidence, in summary. We accept that the case is indeed a circumstantial one. And it is needless to be said that circumstantial evidence isn't easy an effort to make. It isn't easy to prove, but nonetheless, it is a form of evidence that the state can pursue when working towards finding or having someone found guilty. Now, it states as follows: circumstantial evidence is indirect evidence that suggests something is true based on drawing inferences from established facts to establish a fact in dispute. Basically, it is used when there are no direct witness accounts and relies on inferences drawn from other established facts. Now, in this case, the state relies on a combination of forms of evidence, that is physical evidence, human behavior, indirect witnesses, and scientific evidence. Physical evidence being the school bed and so on, and the pillow and so on. Human behavior, the conduct of the applicant itself. Indirect witnesses, such as, I make example of the evidence by the day shift security guard. For example, that indeed Jayden returned, not just returned from school, but he was dropped off at the gate and entered the premises at Swati Place. The scientific evidence being the DNA results and so on from the pillow. It is indeed so that circumstantial evidence, as was stated in the often quoted case of R versus Blom, 1939, it was decided in the then appellate division at 188. Now the specific pages being 202 and 203, because the applicant, the child rather, Jayden, stayed with the applicant, but that's only the two of them. So it would be reasonable to expect that around 4:15, 4:30 of that afternoon, the applicant would be frantic as to why the child has not returned, because it's an aberration now that the time has gone up to 5, but you cannot find the child. And even then, interestingly, according to the security guard, she doesn't ask him about Jayden. He knows. She goes and buys. Then the following morning, okay, she starts making efforts and so on. Now, the following morning, the security guard knows. Not only did the applicant return, she also said she is coming to change. And he noted, but not only did she leave hurriedly, she also did not change. 3, she stated that a transport was waiting for her, but according to the security guard, there was no transport anywhere nearby. The applicant disappeared into the night on foot. Those are what we call equivalent facts. And coincidentally, all along, everyone else was searching for the applicant. In fact, she even said, according to the security guard, or the applicant and members of her family, that in fact they demanded that the security guard search vehicles, not just the vehicles, but their goods as well. Upon entering or exiting the complex. And what made the security guard, the night shift security guard, so alert to the applicant is that she was unwilling or did not seem interested in fulfilling this very request or demand that they had made to them earlier. And that's fine, that's one point of this, but I wanted to come to this one. That interestingly, upon her return that morning, having entered her unit and so on, claiming that she was going to change, then suddenly the body of the child appears. And even soon after she leaves, there is someone then finds the body or finds Jayden, and he is subjected to the indignity of being left outside without any form of clothing or covering. And that also is an indication that the applicant was in a hurry to ensure that Jayden is not found in her unit at unit number 13. The fact that the child was found in that condition is also a strong indication of a person who was in a hurry to just get him out of the house and put him wherever so that he is not found where he was originally harmed, which is number 13. I don't know if to say he leaked out or but was given nonetheless. It's clear the applicant was given that information, but it was limited I'm saying this because now then comes the issue of the applicant having returned to Swazi Place on the 14th of May 2015 at around 4 or 5 a.m. or 4 a.m. Michigan, we want to accept. This evidence is not evidence she was privy to. This is why she omitted it in her affidavit. And that omission, our respectful submission, it was both dubious and disingenuous. And I elucidate dubious. First, the applicant was not aware of the evidence that the investigating officer would tender. So she did not prepare. In fact, if anything, she was blindsided by that revelation. And not just blindsided by the revelation, blindsided by the detail of recording by the night guard security. And secondly, it's this